Welcome back to the Eli Spitzer podcast. My guest today is Rav Shraga Feivel Zimmerman, previously the Rav of Gateshead and now the Rav and Av Beis Din of the Federation. This conversation took place against the backdrop of a new controversy in Anglo Jewry, which has reopened the old problem of the aguna, a woman whose marriage has effectively ended but is unable to start a new one because she has not received a get from her husband. The controversy has exploded after the Federation, led by Rav Zimmerman, issued a statement saying that women who file criminal proceedings for get refusal under the Domestic Abuse Act without consulting Beis Din first will have made any subsequent get issued by the husband coerced and therefore invalid. The statement has been met with outrage. A senior lawyer in the community has said that dayanim have made themselves irrelevant and are highly likely to be prosecuted and end up in prison. Members of the House of Lords have branded the Federation a disgrace, accused it of siding with domestic abusers and of having crossed the line. Others have accused the dayanim of misogyny, sexism, and dysfunction, and placing their court above the law of the land. Rav Zimmerman, welcome to the podcast. I want to give you an opportunity to use this platform to explain what is really going on. But before we get into the details, can you explain how the divorce process works in Jewish law, in halacha, and why the issue of get refusal still exists today?
I thank you for giving me a chance to clarify this. I think a lot of hyperbole you've quoted are just coming from a tabloid newspaper that is anti-religious. I don't think any of us dayanim will be ending up in jail or anything of the like. So it doesn't reflect reality in any way, shape, sense, or form, but it does make for entertaining news, and maybe it livens up your podcast. Now, that having been said this, let's just understand. I met a rabbi the other day, and he said, this couple, I married them off. And I told him, you're mistaken. Rabbis don't marry off people. People get married to each other. You might have said the blessings under the chuppah. You might have overseen it, that it was done in halacha, but people marry each other. Rabbanim do not marry off people. The truth is, even when people tell me I married off my daughter last night, I tell them that means you paid the caterer's bill last night. Your daughter got married to your son-in-law last night. That's what we have to know, that marriage is a voluntary arrangement and relationship that is entered into by two people. In Jewish law and in Torah, these are psukim in Chumash, and nothing has changed over the last 3,333 years, is divorce is exactly the same. That a couple is married and a divorce is a process in which literally in Chumash, the husband writes a bill of divorce and hands it over to his wife. Practically, husbands do not know how to write gittin, so they make a scribe, a sefer, a shliach, an agent to do it on their behalf, and it's overseen by a Beis Din to make sure it conforms to complex and intricate laws. But Batei Dinim do not divorce people. It's a very, very important point. In civil law, it is the court that grants the divorce. It's called the decree absolute. This is an absolute decree. In Jewish law and in Jewish practice, and like I say, this is unchanged and unquestioned, Batei Dinim courts do not grant divorces. We do not divorce people. We oversee a divorce and we facilitate a divorce between two participants in a marriage. That is what a get is, and that process has never changed, and nor is it changeable. By definition, when you're dealing between a transaction between two people, the people have to participate in it, and you have to participate in it. It cannot be forced upon them. In biblical terms, since the Torah is talking about a man writing and giving a divorce, he has to want to do it. In rabbinic terms, it's already over 1,000 years since the time of Rabbeinu Gershom that women also have to voluntarily participate in a divorce. In the last 1,000 years, a divorce are two people agreeing to divorce each other, just like they agreed to marry each other. Now, that might bring up a problem because when they married each other, they were on very good terms, and they were both excited to join this relationship. When they're splitting up, they might be in different places or might have different objectives. And that is what brings the issue of get refusal, because like I say, it is a transaction between two willing people. And like I say, the willing has to be on both ends, the husband and the wife. The problem of get refusal exists both in males and females. As a matter of fact, we don't have proper data, but anecdotally, I've gone over the records of the Federation of Beis Din. I'm only in my role for the last year and a half, and some of it was in lockdown. I went through the records. I've seen the records of the Rabbanut HaRashit, the chief rabbinate of Israel, and the incidences of get refusal are exactly split 50-50 between men and women, because you need the volition of both of them. And therefore, all these words of misogyny, patriarchal system are simply not bound to reality. It's not connected to reality. Might have been a reality 1,000 years ago, but we are contemporary people, not old-fashioned people. And in the last 1,000 years, you have get refuses on both sides. Why do people refuse gittin in experience? Three causes. One, sometimes one side has just not adjusted to the new reality that the marriage is over. Many times people are just not aware of it, or maybe they felt the marriage was good, but the other side felt it's not. Some people have an emotional handicap which stops them from recognizing this. That's one thing. The next thing, which is probably more common, is that one side feels that they're being mistreated. A woman generally refuses to receive a get when she feels she doesn't have an adequate financial settlement, or the financial settlement is not being upheld, it's not being kept. The husband is a deadbeat. A husband generally refuses to give a get when he feels that visitation or contact with his children is being unlawfully withheld from him. That is the reason why the person does it. I'm not justifying it, but you have to understand human nature. Finally, there are a few people that just act out of spite. They have no claims against someone, but they've taken it in their life to be spiteful to others. Those are very, very few and far in between. It's a caricature of it, but it's not thing. And the truth is, and maybe we'll explore it later, is that the amount of cases that are intractable are very, very few. The vast majority of the cases, with the right amount of attention, with the right amount of mediation, with the right amount of hearing people out, in the end, do come to a divorce. But to answer your question, why is there a incidence of get refusal? Is because in Torah terms, a divorce is something which is contracted between the two participants, and the Beis Din just oversees it and facilitates it.
Right. Thank you. I think that provides the background that we need in order to explain what is actually going on right now in the UK. There were a group of people, from what I understand, in the House of Lords, members of the House of Lords, all of them Jewish, many of them identify and affiliate with Orthodox Judaism, who have proposed an amendment to the existing Domestic Abuse Act. And they believe that this amendment could go a long way to resolve, maybe not all, but many of the aguna situation of chained women in the UK. And in response to this, we had the Federation saying that this actually, it might be well-intentioned, but it causes more problems. Can you please explain what this proposed amendment is and why that creates a problem?
Okay. So in 2015, a law was passed which criminalized coercive and controlling behaviors from people that are in a intimate and family relationship. That's 2015. It was debatable whether this will include a couple who's married and legally still married but separated. It is a debatable point. There are lawyers who say it includes this category of people also. To clarify that, in 2021, the parliament passed an act saying that it's even people who were formerly in a relationship, but there's still controlling and coercive behavior. That is also a criminal act. It was not passed in the actual law, the definition of controlling and coercive behavior vis-a-vis giving or refusing a get. There was discussion in the parliament about it being issued as a guidance to judges, that withholding a get is also coercive and controlling behavior, and then it would be a criminal act. That has not happened yet. Now, the Federation and all other Rabbanim, and I must say that anything that we wrote was in consultation with all the other Dayanim in England. We had in-person meetings, Zoom meetings, gatherings of one-on-one, gatherings of public people, and everyone is in agreement on the same issue. And let me explain the issue. Criminal law is by definition punitive. It punishes people for past behavior. It is not corrective. We hope that all criminal law serves as a deterrent to other people from repeating this behavior. However, by nature, it is punitive. And as such, I and other Dayanim have absolutely no problem with the state, or the crown as it's called here, deciding what is illegal behavior and what is coercive behavior and punishing it as such. I have absolutely no problem with it. No, I have no problem with it. We're in full agreement with it. You're not allowed to coerce people. You're not allowed to control people. You're not allowed to abuse people. And the country has every right to punish it. I personally, myself, I believe it's well known, in a totally different type of abuse, went and testified in court a few times against what they would call a Haredi abuser, because I totally believe in that people that abuse other people, that control other people, use their position of power and authority to harm other people. They deserve to be punished. I've lectured on it extensively. It's available on YouTube. I lectured to Australia. I've lectured in London and Gateshead, all over England on the matter. And as such, we have absolutely nothing against the law. We're totally supportive of the law. However, there's one problem. As we said, all criminal law is punitive. It's not corrective. If we want to correct the behavior, which means make the get refuser give a get, that is corrective. That is not within the realm of general criminal law. And that now goes into the realm of Jewish law, that you want someone to give a get, which is a Jewish law and halachic action. Now, obviously, this whole issue only affects people that want to follow halacha. If someone doesn't want to follow halacha, they can just separate without a get, or they can go to other denominations that will grant them a get without anyone's will. The whole problem in the first place, the abuse in the first place, is because there are people who want to follow halacha. Well, in halacha, it's unequivocal that a get which is forced upon a person is not valid. And therefore, if you tell a person, I'm going to put you in jail, I will take away your money, I will shoot you unless you give a get, the get is not valid. As a matter of fact, the language of the Shulchan Aruch is a get bottle. It's not puzzle, it's bottle. It's just plain invalid. And if the husband would then die, and she can then subsequently marry a Kayan, because it has no validity at all. And this is true actually of all transactions. Once we explain how a Jewish divorce works, all coerced transactions are plain not valid. This is nothing new. It's nothing the Federation Beis Din said. Like I said, all Batei Dinim agree with it. I even consulted two very famous get experts in America. They also agreed with it. This has been the Jewish law for a few thousand years, and it's not changeable. Now, the people who proposed this guidance might be well intentioned. They want to help out people that are in a very difficult situation, and I applaud that. However, it has to be in a way that will actually help them and not be counterproductive. Imagine you have a city, and there's a river in the middle of that city, and it's very hard for people to cross that river. So some people decide, you know what, we're going to build a bridge, and it'll be easy for people to cross that river. However, they neglect to ask an engineer whether this bridge is sound from an engineering perspective. Then along comes an engineer and says, I'm sorry, the bridge is going to collapse and all the people are going to fall into the river. Now, I understand the frustration of people who worked so hard on building the bridge, and they see it's really so important to have a bridge, but ultimately it was their decision to build a bridge without asking an engineer, and an engineer has to just give their professional opinion on the matter. And therefore, and the fact is, nobody should be building bridges without asking engineers. No one should be inventing vaccines for the most recent pandemic without addressing medical authorities, no matter how important the cause is. And therefore, that is what happened, and this is what we flagged up. This is what we flagged up to people. There are other solutions to this, other ways of dealing with it, but I knew I answered your question.
Yes, but there's one obvious question that comes to mind, that it is well known that in Israel, get refusers can be punished by the Israeli state, including in extreme cases with lengthy prison sentences. What precisely is the difference between these laws, recognized and endorsed by the rabbinate in Israel, universally accepted as legitimate, and the law here in England, which seems, if anything, to be even milder than what is being enforced in Israel?
In Israel, the civil courts, enforce the decree of a Beis Din. A Beis Din, in limited cases, can rule that this marriage is a marriage which what we call is kaifin. You force the person to get divorced. These are cases which are enumerated in the Mishnah and Ksubis. They're found in Shulchan Aruch. Let's just give one example. A person has a contagious disease and he'll infect his partner. In that case, a Beis Din can rule that you must get divorced. In Israel, it goes the other way. Since the Beis Din is part of the Ministry of Justice, the case first goes to the Beis Din. The Beis Din, in certain cases, will rule that this is a case of kaifin, which is what we refer to as kaifin oisei ad sheyomar reitzani. You force a person until he says he's willing. Then the civil courts enforce the Beis Din ruling. That is totally valid in halacha, because the Beis Din has ruled that it's a case of kaifin. The civil court is acting as a bailiff on behalf of the Beis Din. Now, this is not, it's most well known from Israel, but to best of my knowledge, in Holland, in the Netherlands, they recently passed a similar law also criminalizing not listening to the decree of a Beis Din that you should get divorced. Over here in England, you're trying to criminalize it without a Beis Din ruling on the matter. We don't know what Jewish law says on the matter, and therefore using criminal law and a criminal prosecution to force someone to give a get, which a Beis Din has not ruled on, is not valid.
So what I'm trying to understand, to unpick here, there seems to be two things happening at the same time. There seems to be a question of who should be responsible, who should initiate the coercion. And there's another question of when coercing a husband into giving a get is actually justified. Say in circumstances where it does meet that threshold for coercion, why does it matter who does the coercion? Why does it matter? Say that the fact is that Beis Din agrees that this recalcitrant spouse should be coerced into giving a get. Is it a case of just trying to protect Beis Din's authority, which is a larger strategic goal, as opposed to actually a problem in matters of halachic matters of divorce?
No, it's a plain matter of halacha that it's based on a pasuk shoftim v'sheitrim titin lecha, that first the shofet has to rule and then the shoiter enforces it. And it's learned out from that pasuk that is the order and that is the process that has to be followed. So if you're going to use absolute force and coercion, like taking away someone's money, incarcerating someone, physically beating a person, then you have to follow this process of shoftim v'sheitrim titen lecha. Now there are other methods of coercion, which one can approach it differently. Should I explain that?
Yes, please. I mean, I know that the things that we come across as a member of the community would include things as naming and shaming people and refusing to allow them entry into local shuls and so on. But I would like to, if you just don't mind, just expanding on why does it matter? Why, to use a phrase from the statement of the Federation, that the hands of the Beis Din will be tied? Why, if a secular judge has ruled that this husband abuses his wife by refusing to give a get, why does that undermine the Beis Din's position?
It doesn't undermine the Beis Din's position. It just makes it that the person is giving a get because he's forced to give the get, not because he wants to give the get. It's not undermining the Beis Din. We have, like I say, we have no problem if the judge feels that this is an abuser and puts him in jail. That's, be my guest. But it will be counterproductive if the purpose is to achieve a get, because a get which is coerced is just not valid.
Right. So can I just follow that up by asking, why is it necessary for each individual case to come before Beis Din to make a judgment of whether this man can be coerced into giving a get? Why can't Beis Din or many Botei Din get together and establish right along tshuva, establish the criteria for when coercion is justified and is legitimate, and based on that, people can make a decision whether they want to pursue criminal charges?
Well, in Jewish law, you're going to have to meet the burden of proof to coerce someone. And like I say, if they both want to give a get, we shall do it. We are talking about someone, for whatever reason, rightly, wrongly, usually wrongly, doesn't want to give a get. And the other side is claiming that there are grounds for coercion here. Now, someone has to adjudicate this dispute. The person who adjudicates it has to be totally unbiased. No one's going to come to a judge that has an agenda and wants to see a certain result. People are only going to come to a judge, and a judge by definition must be unbiased to hear out both sides and decide what is the truth in this particular situation. And like I say, that is the process that the Torah lays out, that it goes from shoftim to shoiter. This brings us back to the law of 2002, the Divorced Religious Marriages Act of 2002, which was made by the parliament, which said that if someone is encumbering his spouse from remarrying, like a religious person who doesn't give a get, the court will not award a civil divorce. This law was made in 2002. It was in consultation with many rabbanim. I think the person who organized it all was Dayan Beryl Berkowitz, of the Federation Beis Din. And I've spoken to lawmakers in the past few days of people who cooperated and worked together with him. And what he explained to people, and this is self-evident in Jewish law, that there's a difference between withholding benefits from a person or sanctioning a person taking away from a person something that's rightfully his. No one is entitled to a benefit. And if you withhold a benefit from a person because you're unhappy with his behavior, you're entitled to do so because he has no entitlement to this benefit. What Diane Berkowitz explained to the lawmakers then is no one is entitled to a civil divorce. This is something that the crown or the state grants someone. He's not entitled to it. And therefore, the crown could say, I'm only going to give it to you if you conform to, my code of behavior. This idea of ostracizing a person, this was the idea of Rabbeinu Tam, one of the great Balei Tosfos, that no one's entitled, that other people should speak to them, should let them into their shul, to get an aliyah, to say Kaddish. All these things are not things that are people that are entitled to. And therefore, the community as a large have a right to withhold this benefit if a person is, unjustifiably withholding a get, even if it doesn't reach the level of kaifin. As long as the Beis Din says that in this case, you should be giving a get, you can withhold benefits from a person. And that is all these ideas of ostracization and the 2002 get law. Now, without divulging names, we've met in the past few days after our letter. We've met with various women's groups. We've met with parliamentarians, and they came to ask us, what could we all want to solve this problem. It's heartbreaking to see someone who wants to move on in life and can't just because someone else is still holding on to them. What would be acceptable in Jewish law? And the answer was very simple. And again, I don't know civil law well enough to know whether this is legal, is that you can withhold all benefits from the people. Imagine you say, someone doesn't give a get, you won't get a driver's license, you won't get a passport, you won't get housing benefits. All of a sudden, people might look at it differently. And the government has every right to do so because these are benefits that no one's entitled to, and you're withholding the benefit. And you should know, as you explain it to people, and they realize, something, the Beis Din is not trying to control anyone. The Beis Din is not trying to aid and abet a bad situation. They're trying to solve it, but in a way that is productive and in a way that is corrective. And there are many, many ways of withholding benefits that it will be so painful, except for the most, outlandish refuser. There are many ways of doing it. And that's what's happening in the past few days. So while the letter might have created an explosion, and like I say, the explosion is just largely a product of tabloid press, which we don't take so seriously. The reality is that it woke people up to the reality that, this is a complicated issue. It's not as simple. We wish we could easily, resolve it by passing a law in Parliament. But something, we might have to touch it up. But working together with the Batei Dinim, and like I say, everyone we spoke to understood it and understands it and says, okay, so now let's redo it slightly. And like I say, the guidance has not been passed yet. The law has been passed that coercive and controlling behavior, even when people are separated, is illegal. But the definition of that has not been passed, nor have the sanctions been passed. And there's still a lot of time to correct this and to write this. And like I say, to use the cooperation of the Batei Dinim, who in the end have to give the gittin and have to facilitate the gittin, together with those who have the authority to make it happen.
I think that really, for me at least, clarifies what this particular standoff is about. And it would be interesting to see how it will be resolved. But I think if we can zoom out a little bit and talk more in general about the problem of agunas, the plight of agunas, as it's called. I don't think anyone in their right mind will deny that for a woman who finds herself trapped in a chained marriage without being able to move on is a horrific experience and it is devastating. People often say, people who are admittedly critical of maybe the rabbinic establishment, but there is a phrase that people say, where there's a rabbinic will, there's an halachic way. Now, if you go back and you think of various halachic innovations, going back over centuries, from the prosel, for example, which allows people to continue to recover debt after Shemitah, or mechiras chometz, which is quite an innovation, allowing people to sell the chometz instead of destroying it, or maybe the eruv. Some people would see that as an innovation, as a leniency instead of a stringency, depending on how you look at it. Is there some truth to the matter that there is just a lack of urgency from the rabbinic establishment to find a solution to the Aguna crisis? I mean, how would you respond to that?
Okay. So now, all these things you mentioned, from a prosbul to mechiras chametz to an eruv, are all found in Jewish law already. They're all based on principles that exist within Jewish law. And eruv, it happens to be the worst example, because there's a whole masechta called eruv, and how you build. And how you build an eruv. Where you build an eruv might be contentious, but how to build an eruv there's a whole masechta about it. Hillel made a prosbul based on existing halachic principles, and mechiras chametz is based on an existing principle. There might not be this existing principle at the moment, to be able to address it. Now, this slogan, if there's rabbinic will, there's a halachic way, is a very nice slogan. It's a slogan for conservative Judaism in America. But it's not reality. It doesn't speak to reality. I'm telling you, I'm a little bit older than you, as you can tell by the color of my beard. And I remember when conservative Judaism was in ascendancy in America. And this is the wave of the future. These are people who keep halacha, except they just bend halacha to fit to their, to contemporary times. Look at it 30, 40, 50 years later, and you'll see that they're falling apart. So this idea that a rabbi could do anything he wants is not so. I was once on a plane. In an earlier stage in life, I worked on the Beis Din of Kaladas Yishuron of Washington Heights. And I was supervising a product, Dole Vegetables, in Soledad, California. You had to fly into San Jose, California, drive down Highway 1, and Soledad is a big jail, is a big prison, and they have fields there, and the prisoners work in the fields. And I went to check it. It's not all that comfortable to be surrounded by prisoners while you're checking lettuce in the middle of a field. Anyway, on the way back, I ordered a kosher meal on the plane. And this was after a full day work. I was taking the red eye back from California to New York, and they didn't have my kosher meal. And one stewardess was very, very empathetic. And she said, "Rabbi, can I bring you a non-kosher meal? And you'll say a benediction over it before we put it into the oven, and then it will turn kosher." And I said, "I'm sorry, it's just the wrong religion." So no, I don't think there is that there is a magic bullet. But I must tell you like this. Like I say, the amount of intractable cases are not that many. And I can only tell you from my own experience. And the problem is, in all these things, everything is anecdotal. And therefore, everyone can take the one case they saw and then use it to further their agenda. But I just went through the records of the Federation over the last 5 years. Now, the vast majority of our gittin are two people who come in and want to get divorced, and we facilitate a divorce. They come in at 10:30, 11. By 1:30 before mincha, they are divorced and they go home. Then we've had, over the last 5 years, probably 16, 17 cases of people who one side didn't want to give a get. Of them, 4 of them we arbitrated. There were another 9, which 5 of them, the woman refused to receive a get, and 4 of them, the man refused to give a get. And by listening to them and counseling them, and by wearing them down and helping them out, eventually they all gave the get. I would say there's another 3 that the same thing will happen. There are 2-3 cases that seem to be intractable. Now, each one of them is a heartbreak. But like I say, the vast majority of cases with patience, with efforts, and it needs all types of efforts. The Beis Din has to put in effort, the community has to support it. If the law can support it, that's even better, in fact, are solvable. Sometimes it's comical. We had a man who was a get refuser, and after all is said and done, he said, "What do you want from the person?" He said, "Really, I want to give a speech for 20 minutes that I'm not responsible for the divorce, and then I'll give it." So I said, "You know something, do me a favor. You're going to give the get, and afterwards we're all going to sit in the audience, and you're going to deliver your speech." And he delivered his speech, and he was satisfied. We had people who demanded apologies. We've had people who have all types of things, but largely, like I say, largely it's all a function of human behavior. And these people are people that are hurting, and people that have been hurt in life and have been disappointed and demoralized in life. And the solution is not always to put everybody in jail who's demoralized and hurt, but rather many times it's to hear them out. And like I say, our numbers show, and like I say, the Rabbanut in Israel reflects the same numbers, that the get refusers of male and female genders are equal, and the vast majority of them are resolved in one way or another. And if the community would support the efforts, maybe with ostracization and the like, it would work even quicker.
Right. Just to go back and just to explain, the reason I use the phrase, if there's a rabbinic will, there's a halachic way, I meant specifically a halachic way. I didn't say if there's a rabbinic will, there's a non-halachic way. And I'll give you one example, which is the halachic prenup, for example, which in the United States, I think there's I don't know exactly how to describe the Yeshiva University world. I don't know if that's all of modern Orthodoxy or just a section. It seems pretty much standard that the halachic prenup, which hopefully the Rav can explain what that is, but that seems to be a bit of an insurance policy against a potential get refuser. I haven't seen in my community any sort of urgency to find this potential halachic solution that might prevent a case of a get refuser abusing his wife. That's why I asked, is there a lack of urgency? So about the halachic prenup, I mean, maybe it's worth explaining what that is, but also why that isn't promoted more.
Again, there are many different, the word halachic prenup is a general term. There are many, many different halachic prenups. Some are valid according to all opinions. Some are valid according to some opinions. Some are valid to majority opinions. There are many, many different halachic prenups of different levels of effectiveness and different levels of halachic acceptances. There is even a halachic prenup, to the best of my knowledge, written by the London Beis Din. And the truth is, we are also working on a certain idea, but you're going to have to find the one that will sell to this particular crowd, because halachic prenups are only good if people willingly enter it. You can't, again, force them to enter it. Furthermore, like I say, once someone is married, you can't write a prenup anymore, and we have to find solutions even for people that are married. So it could be with time, it will think it's not going to it will not solve every case, and you need to put all efforts into it. It's beyond the scope of today to analyze each one and say its strengths and weaknesses.
Right. There's one more question on the subject of Gittin, which, from what I understand, I think there is hard data to support that. An extremely high proportion of the Gittin that are granted involve substantial payoff from the wife to the husband. Isn't that just simple extortion? And is there something, why doesn't the Beis Din do something to stop it?
Okay, so now again, you're getting all your information from tabloid newspapers. I'll tell you, I personally have been at the, so to speak, at the apex of rabbinics for over 25 years, and I haven't seen it. So it's probably not standard practice. I'm not saying it doesn't happen, but it's probably not what happens all the time, because I probably would have picked it up along the way. Like I said, I went through the records of the Federation over the past 5 years, and I found only 2 cases of someone asking for money. And I think it will illustrate. I have to change the cases a bit so as not to violate people's privacy, but I think you'll understand the underlying issue. One couple were both happily married. They lost their spouses. They get remarried. And the second marriage, like all second marriages, has its difficulties. The wife is happy. The husband is not. The husband wants out. He wants again. The lady says, listen, when I came to marry you, I gave up my apartment, I gave up my job, and there were expenses involved over here. I had to relocate, and I want you to compensate me. Since you're the one who wants the get, I don't want the get. I want you to compensate me for it. And she named a certain figure. Now, let's analyze this for a moment. Is she justified in her claim? No. Divorce is an occupational hazard of getting married, and certainly an occupational hazard of second marriages. She's not justified in the claim, but the claim is largely, understandable. She's not extorting money. She's saying, listen, for me to get back to where I was, it's going to cost money. Now, the Beis Din didn't get involved in saying whether she's right or wrong. We just stepped back and let the people negotiate amongst themselves. And they, in the end, I think they agreed. But I don't think she's an extortionist. I don't think she has a claim, but I don't think she's an extortionist at all. It's understandable. I'll tell you one more case. It just so happens to be that both the cases in the last 5 years were women, but it can be at both ends. Man and woman get married. They separate. Each one went on in life. Each one, I think, was already living with someone else. 10 years later, the man calls up his wife, although he considers him his ex-wife. I would like to give a get. What's today? Well, the person I'm living with wants to marry me, and she was informed that she can't marry me unless I have a get. His wife gets very, very upset and says, listen, 10 years you ignore me. 10 years. Now you want me to come take a get because you want to marry someone else? Get lost. And her anger is, I understand it totally. Eventually, the anger turns in, get lost unless you give me X amount of money. Now, is she justified in money? She didn't explain any reason why she deserves to be compensated. But her hurt and her pain are real. This is a broken-hearted person. This is not an extortionist. This is a person who's hurt and understandably hurt, and somehow the money in some way makes people feel better. Here again, the Beis Din just walked away from it because there's no justified claim. It's nothing we can adjudicate. And they had to decide amongst themselves whether they want to pay the money or not. To the best of my knowledge, I couldn't understand, but I think from the files, I don't think the divorce ever went through. That having been said, I'm just illustrating to you, again, real life cases, not made up cases. Now, I cannot deny what I've not seen. Chazal say, Lo re'inu ein raya. If I've not seen something, doesn't mean that it didn't happen. It might have happened. I've never seen it. But I could tell you, A, it cannot be something which regularly happens, and I'm not aware of it. Number two, there is a context to a lot of these things. It's a bit cartoon-like to say that people are extorting. Maybe there are extortionists out there, but there are extortionists in business, there are extortionists in all parts of life. There are people that are blackmail in all parts of life. But the vast majority of cases, even when money changed hands, it's for some perceived hurt, some perceived resolution, some perceived appeasement. It's not easy to go bang the table and say, you know something, you have no right to the money, do this right away. First of all, we can't force a get. Like you said, we can only facilitate a get, and we need the goodwill of the people. That's step number one. Number two, if you're a person with a heart, you do understand where people are coming from. It's not just, let me rip off someone. I have an opportunity to rip off someone. I'm not saying there aren't rip-off artists out there, but there are rip-off artists in every facet of life, and you're not going to close down business, and you're not going to close down communications and media and entertainment and whatever, just because there are a few extortionists. But I can tell you that it's not common practice. I would have come across it. I've served on 3-4 different Batei Dinim in my life, and I've never seen it. Like I say, I went through the records, and they were, first of all, rather small amounts, and they were all people with with a certain sense of aggrievement, which they wanted to address this aggrievement, whether it was logical or not. It's not a thing. And that's what I'm saying. Most of the cases you're dealing with emotion, illogical emotions. You cannot necessarily judge them in pure legal terms. You're dealing with emotion, you're dealing with people. You're people that were disappointed, people that are disheartened, people that are broken. And many times you just have to sometimes just listen to them. You know, there is a case, my predecessor, Dayan Lichtenstein, was famed for his being able to get gittin out of people who didn't otherwise think. And he told me a story. There was a person they put in jail in Israel for 15 years. And 6 of them were in solitary confinement. And this person refused to give a get. And he went to Israel, visited the person in prison, and had the person talk to him for 12 hours a day how evil his wife was. And after the end of the week, Dayan Lichtenstein said, listen, it must have been terrible, but it's not worth it to ruin your own life just to spite someone else. And he said, you're right, be my shliach to give a get. So you should know that, like I say, it's a bit a caricature and cartoonish to think that everyone involved in the divorce are evil people trying to take advantage of each other. It's largely hurt and broken people that need to be listened to, need to be assuaged along the way. And like I say, I've checked the records in the Federation over the last 5 years. The vast majority of cases were resolved. There were get refuses on both sides. Their reasons made sense emotionally. They didn't necessarily make sense logically, but they made sense emotionally. And when you get past it, people do give gittin in the end. And the few people, I think we're running out of time, but the few people that think we need an all-out campaign. The Batei Dinim, and yes, Batei Dinim can work harder, but Batei Dinim, a judge by definition, has to be reactive, not proactive. Because if you're a proactive judge, you're no longer a judge. It's something like progressive judges in the United States. You're no longer a judge. You're just legislating from the bench. But we can't legislate from the bench. And so we need an all-out campaign, communal organizations, kehillas, women's organizations, men's organizations, and whatever the law can contribute, we should all get together and stamp out the problem to the best of our ability. We're never going to change human nature, but we can stamp out the excesses of human nature.
Rav Zimmerman, thank you so much. It was really an honor and a privilege, and I think a real opportunity for people who really do want to have the perspective of a Rav in all of this, and I think this will be really helpful. So thank you very much for your time.
Okay, thank you for having me.